इरेजर बसेर रहेछ भने कहिलेसम्म अर्डर दिन्छ भने 2 दिन जस्तो भयो आएको छ त्यो चाहिँ उसले पनि भन्दै थियो अस्ति त्यो माथिबाट आएर पनि प्रोसेस हुन लागि 2-3 वर्किङ डेज लाग्छ भन्दै थियो क्या 2 दिन त भयो नि त अस्ति स्याटरडेतिर स्याटरडे कहिले आयो आज वेडनेसडे भयो मन्डे ट्युजडे भयो यो डेज अफ जुनमा 21 देखि जानु थाल्छ होला हौ उसलाई 21 सम्म आउँछ है क्यान्डिडेट पोस्टिङ के को थियो त्यसमा यो आई थिङ्क आफ्टर इलेक्सन तर लाग्दैन इलेक्सन अब हामी चाहिएको छ नि मान्छे इलेक्सनको लागि अलरेडी सबै मिलाइसक्यो
Good morning, everyone. With the permission of the Learned Director, I, on behalf of Sikkim Judicial Academy, would like to begin today's session on Indian Evidence Act 1872. To conduct the session, we have Mr. Benoy Sharma, Learned Central Project Coordinator, High Court of Sikkim. I would now request Learned Director, sir, to kindly welcome Learned Resource Person by offering Khata and followed by welcome address. Thank you so much, sir.
Good morning to everyone present here. Today is the second day of the session of today's program. In this occasion, I have the privilege to have benign presence of the learned resource person, Mr. Benoy Sharma, Central Project Coordinator, High Court of Sikkim, who, despite of having a number of important assignments pending before the Honorable High Court of Sikkim, has been kind enough to accept our invitation and come here to deliberate on important topics of today's program. In this occasion, it's my unique privilege to extend a warm welcome to you, to him. Service in the year 2012 as a civil judge cum judicial magistrate. Then thereafter, he was promoted and hold the post of Chief Judicial Magistrate cum Senior Civil Judge at Gangtok as well as Mangan also. Then thereafter, he was transferred to District and Session Court, Galsing. Thereafter, this year only in the month of July, he was promoted and now presently posted as a member of Sikkim Superior Judicial Service, that is the post of District and Session Judge. Now he's being presently posted as Central Project Coordinator. Now with this brief sharing of profile, now I would like to request the Learned Resource Person to kindly proceed with.
I have been in this service for the past 11 years, and majority of my job profile till date was in the magistracy as a judicial magistrate and as well as chief judicial magistrate. Recently, I've been promoted to the district judge cadre, so I've left magistracy where where we see more police officers, more than the district and session judge. So the faces are familiar to me, except him and I find similar face where I've seen maybe. So kindly introduce yourself so that I may know with whom I'm interacting, right? Yes, ma'am. Again, switch on your mic.
Good morning, sir.
Good morning, sir. My name is Siddharth Siva and I'm presenting.
Right. 2020 batch. Currently, I'm posted at Rambu PS.
Good morning, sir. My name is Sangeeta Khatiwada, 2020 batch sub-inspector. Currently, I am posted at Ranipur PS.
Good morning, sir. My name is Purchering Lecture and I am presently posted at Ranipur PS.
Good morning, sir. My name is morning, sir. My name is Norki Lachempa. I'm posted in Sadar as of now, sir.
Good morning, sir. My name is Kajan Chadan Vidya and presently posted at Sadar PS.
Regarding evidence, because this is the area where we not only investigation, even trial depends upon evidence and the ultimate outcome, that is the judgment also. So you can share your experience which you have investigated and where you have felt that sometimes you do feel that certain evidences which has to be collected according to the law, right? But I understand, I have seen the police officers, sub-inspectors who are quite experienced, even the police inspectors, even the DSPs, particularly from the sub-inspectors, that sometimes when they were working according to law, but certain practices are there, which has come down from generation, even in the police system. And without application of mind, that is blindly followed. So those could be the situations which you may have faced, where you thought something else, but your superior told you to do something else. So you can share if you have anything like that. And okay, let's begin with what do you understand by evidence? Don't feel anything awkward, okay? Of course, sometimes I am on that side, I do feel. So thinking that others may also be like me, I'm just saying that don't feel awkward. We feel awkward more than with the resource person than with our colleagues. They might think that I don't know. So don't feel awkward and give a general understanding of evidence. We can forget the act also for a moment. What it could be from the perspective of your investigation. You can include the definition that is provided in the act also. Anyway, evidence, keep with something. Because since you all are 2020 batch, just 2 years old, that's why I'm going a little bit more in detail, okay? Had it been experienced police officers, I would not have gone in this detail. No, would not have asked this question, probably.
So in layman's term, the evidence is anything like any object where he has done some.
Can it only be object? Yes, absolutely correct. Object is one of the...
Not just objects, or anything, so any circumstantial evidence means whether previous conduct, subsequent conduct, which may link him to certain crimes.
It can be a statement of witness also, I would add that, right? So, see, before trial, evidence means and includes all statements which the court permits, right? You may have gathered everything, but what comes in the as a record is only that is permitted under the Evidence Act. Loosely or generally, we may call all those things that are brought during investigation as an evidence. Though technically, if you go to Evidence Act, it's still not evidence. Unless it is put to proof in the court, it is still not evidence. But generally, we can say, yes, whatever you have collected is a proof which gets converted into evidence. The real evidence, once the court accepts it. Court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Now, if we see this, it says all statements which the court permits or requires to be made before it by witnesses. Why it is saying by witnesses? You have said object, right? Why this witnesses word could be here? It's just a common sense. Because objects don't speak. If you bring a stone, right? Except the documents. Sometimes the document speaks for themselves. In fact, in law, documents should speak for themselves. So if you bring a stone, someone has to say, what is that stone? Right? So that is why it uses the word witnesses. The deposition which the witnesses give to the facts which is in their knowledge, which they have seen, or which they have heard, or which they have perceived by their own senses. We must be very careful on this. We have heard about hearsay. What is it? Yes, sir. Let's ask you.
Somebody knows that, like for example, A commits a crime and B tells C that A has committed a crime. So that will be hearsay. C will be
Yeah.
hearsay.
Yeah. Hearsay means you have not actually perceived, the witness has not actually perceived the thing with his own senses. A witness has to perceive the things with his own sense, either with eyes, if it's a smell through his nose, right? If he has heard a blast through his ear, he can't depose that, Mr. X was saying there was a blast. If that is his only evidence, right? But if he says, yes, after hearing him, I went there and I saw, debris around there, that is a direct evidence. But there's a confusion regarding hearsay I would like to tell you. So let's take, for example, if I come to you and say, I saw Mr. X murdering Mr. B. If I come and say you. Now you cannot depose on what actually happened there. But what I said you is not hearsay. The statement that I came and said you that I saw a murder is not hearsay. That has been directly said to you. But you cannot say there was a murder. I heard from you. Got my point? मैले तपाईलाई गएर भनेको त statement fact हो नि त. That is a direct evidence. But what happened out there, on that you cannot depose. You can depose, but the court will not admit it. It will be rejected. Now actually, if you go by the Evidence Act, it's very difficult to be perfect on this. Because even in the court, when the trial goes, there's so many things taking place out there. If you really stick to the Evidence Act, then everything will become very narrow, including your investigation, including our trial. I would admit that the trial proceedings in our court also sometimes, unnecessary things comes on record, even while recording evidence. Because, we tend to forget that that particular thing was irrelevant, very minute things. The broader things, the court gets to know that this cannot be admitted, and it stops it from coming the record. When the things are inadmissible, it should not come in the record at all. I have seen in cases of the public prosecutors insisting to mark a Xerox copy. It cannot be. What is not admissible will never come on record. Okay, the moment you bring it on record, you are in the Evidence Act, so that irrelevant things does not come in. And if irrelevant things come in, the whole the process gets derailed, or it moves on to some other track. So that's why Evidence Act is very, very important. It is one of the most important law in the whole criminal trial proceeding. CRPC is procedural law. Even if something is violated there, sometimes it doesn't matter. But Evidence Act being violated, there will be a problem. So, see, someone comes and lodges a FIR, right? That too becomes evidence one day. Even it may be a FIR at the initial stage, it becomes evidence one day, but though not a substantive evidence. Now, two things you must be keeping in your mind. There are two words commonly used in law: substantive evidence and substantive evidence and evidence which is not substantive. Is FIR? Why is FIR is not a substantive evidence? Can you tell me why? It's the first information. It is never considered a cogent proof in trial. It's not my creation, it's law's creation, okay? Because the role of FIR is only to give the information. Moment that is done, its primary job is over. Don't ever rely on FIR as your heavy proof for you. Police officers do make this mistake. It has been said in FIR. FIR's job is over the moment it reports. Of course, it does have a value later on, but as an evidence, it's nothing much. FIR tells you what happened. Now you are not sure whether that FIR is true or not. That is why investigation takes place. Now, often it is seen that the investigation officers. I understand your problems also. Someone who is at Southern PS may not get time to sleep also, right? So, of course, those problems are there, but when you come to court, no one will understand that. Because it can't be understood, because the court wants the job according to the law. You may tell them, I couldn't sleep. Sometimes the court, okay, you will do this thing. Alikati laxity dinu sakcha, but when it comes to work, it will not. That's not my problem, Judge. If you didn't sleep, right? If you had too many cases with you, judge will not listen. So for you, things have to be done properly. So when I've seen police officers relying heavily on FIR and saying this, it is absolutely forget FIR, your investigation. It gave you the information. primary information of a cognizable nature, that's why it was registered in the police station. It's giving you the basics. Now your duty is to find out whether it's true or not. Usually what happens is police officers try to build their case upon the FIR only. That might lead you to wrong places. Of course, usually in our state of Sikkim, there are very rare false FIRs, but that tendency will grow now. You know, whatever is happening in the other cities will happen here eventually one day. You know, especially in the East, there we have seen false FIRs, right? So don't rely heavily on FIR as an evidence. Person may be lying you, he or she might be misleading you, right? And the complainant statement, that becomes an evidence one day, but it is not that, you know, it is a gospel truth. That is why investigation is being done. Someone may have been falsely implicated. Because the principle of criminal trial is, which applies to your investigation also actually, which practically is not done, is that, you know, no person can be said to be guilty unless proved. Right? Still you have that on you. You begin investigation with that only. But yes, as soon as you get the proofs, then your cases become more concrete and then you move on. Now there are, Evidence Act is not very vast, but it has many sections. The only things which are relevant I will deal with you all. One is section 27, which you have heard, no? 64B is there, and dying declaration, and then the primary and secondary evidence. These are the things which are more important to you all. So we can start with section 27. Anyone, I think you have done 27, right? Who hasn't done 27? I don't see a police officer who has never used 27, especially in theft cases. And I even know what actually practically happens while recording section 27. Anyone, section 27 experience, and anyone has got a conviction? You got, what was the case?
Assault case, एक्युजले चाहिँ त्यो रम्बाले हिर्काएको रहेछ हो, त रम्बाले चाहिँ उसले चाहिँ रम्बा लगेर चाहिँ लुकाएको रहेछ उसको घरमा लगेर, अन्त उसले कन्सिल गरेको थियो, अन्त बादमा उहाँलाई राउन्ड अप गरेर लिएर आएर हामीले सोद्धाखेरि चाहिँ उसले भन्यो कि मैले यस्तो यस्तो गरेको भनेर एडमिट गर्यो, अनि बादमा हामीले दुईजना विटनेसको अगाडि चाहिँ त्यो पहिला उसको स्टेटमेन्ट रेकर्ड गर्यो, एन्ड देन त्यो स्टेटमेन्टको त्यो पार्ट मात्रै जुन चाहिँ उसले भन्दै थियो कि मैले लगेर त्यहाँ लुकाएको छु या फिर कन्सिल गरेको छु यस्तो यस्तो गरेर आफ्टर कमिटिङ द क्राइम, देन हामीले त्यो विटनेसलाई ल उसलाई नै लिएर गएर उसले हामीलाई त्यो ठाउँ देखायो कहाँनिर रहेछ भनेर, देन हामीले त्यो हेरेर फोटोग्राफहरू गरेर चाहिँ त्यो सिल गर्यौँ इन प्रेजेन्स अफ दोज टु विटनेसेस.
How relevant was that fact in your case, in achieving the conviction? What were the other evidences in that?
अरू त त्यस्तो केही थिएन सर. दुईजना विटनेसेस हुनुहुन्थ्यो, उहाँले पनि
आई
विटनेसेस, तर उहाँले पनि भन्नुहुन्थ्यो जस्तो अघि तपाईँले भने जस्तै देखेको चाहिँ उनीहरूले अब देख्नु चाहिँ देखेन, हिर्काएको चाहिँ तर झगडा परेको जस्तो चाहिँ लाग्यो भन्नेहरू मात्रै हुनुहुन्थ्यो त्यस्तो.
Which court was it where you got the conviction?
JM court, sir,
Mohan. Which year?
This year, 2022.
Okay. So, 27 ma pani euta 27 my case is foolproof. No. 27 is your extra pocket money. You must get something else to satisfy yourself. My case is foolproof. Then just relying on 27. Now one more question. 27 ma we can use only one thing in 27. Can anyone tell what is nothing wrong in that? But you know, witnesses might contradict what your case is. Right? So you have to be very careful on this. I had one case where I was thinking of conviction, but I was transferred in the mid-trial, where it was a theft case of Ranipur PS, where mobile phones were stolen from the shop at night, and then section 27 witnesses started coming. The one witness was useless. He didn't know actually. The one was a girl witness. I think she's some kind of a social worker. I see her at Ranipur quite a time. And then she said, yes, the accused did disclose where he has hidden the mobiles, but this document was made later on, after we recovered. Now, as you know, once it is witness says that the document was made post-recovery, your whole thing fails. Right? But what I got in that case was, the witness the accused had disclosed before a police officer, but police officer did not jot it down at that very moment. He went to the place, got it discovered, came back, okay, and then the document was made. The only flaw in that it appeared was that the document was made later on, but it still did not wash away that the accused had made a disclosure before a police officer in the presence of witnesses. So I considered that just making a document later on was not fatal. Disclosure to थियो नि त, witness ले पनि सुनेको थियो. कागज मात्रै बादमा बनायो. I am not relying on कागज. I am relying on what the witness is saying, oral version. When I was convinced in that regard. Okay, so in law it is not required it should be in writing, but that does not mean don't make it in writing. When you keep something in writing, it becomes more strong. Right? Because usually it's been 2 years for you now. Now once you grow in that police station, you will stop finding witnesses for you. You may have to beg or you may have to threaten. Actually, the law says if someone refuses to become a witness, he can be punished. It's a criminal offense actually. But usually you can't do that in a small place like this, you know. Every now and then you'll be meeting that person. So it will be usually the persons whom you know or who usually come to the police stations who sit as witnesses. And to be frank, you know, what practically happens is, since police officers don't find witnesses, what you all say is, nothing will happen, please come, just sign here. Right? And that person signs it and he comes and tells in the court, this police had said to me, nothing will happen, and today see I haven't done anything, because you know people are afraid to come to court. Actually there's nothing wrong. Even when I was a judge, I used to tell them, some people used to say, so I haven't done anything, why I was summoned? You are a witness, I used to tell. But I haven't done anything. So I used to tell them, you need not do anything to come to court, you are a witness. And they used to say, from next time I won't sit as a witness. And I used to tell them, see, if you would be the victim and someone would refuse to speak in your favor, then how would you feel? Did anyone kill you out there? No one shouted you. Just enjoy the process and go away, I used to tell them. So you will stop finding witnesses also, okay? So in 27, always remember, be true. Try to be true. Don't try to, you know, make things in 27. If it is not a recovery, don't make it. Don't make a forced 27. It will go against your case. The judge will know it. Someone or the other from the case, trial. That is how the cases get updated. The more you bring a true picture, the more chances of conviction. Because the court does not want a made-up story, even if it is fitting in the evidence. The moment the judge gets the doubt, the judge will continue with the doubt. But if your procedure is also flawed, what you have brought is truth, the court will believe it. So don't forget this ever. Though you will be under a lot of pressure not to do this actual thing, and there will be circumstances. But still try to bring the truth before the court, and that can be done when you bring the true facts. You have to go also, there's a dead body lying. Right? And you reach there and you suddenly find someone from that group says, I did it at the house. And I've hidden something out there. Will you come back to police station, get the witnesses, and then make sense? You don't. That what was said to you, there could be any other person out there who has heard it. That can still be treated as disclosure statement. But what usually happens is, now there is something in your mind, I have to make a paper, I have to get the witnesses. So you complete all your processes there, dead body is also taken to the hospital for postmortem. Some things are seized out there. You come back to the police station, you call two person, and then the accused will be in your custody, and you will again ask him out there. Okay, then you start making 27. Sometimes this may go against, because the witnesses might say, no, he had already said there. So there cannot be a second 27 statement. The court will now start doubting all your process which you have done. The court starts disbelieving the IO. And once that gets in the mind of the judge, it will be difficult to take it off. So you can be true to it. You can record it out there, and why you want to come back to police station? There's no problem. You have arrested the person. Obviously, first thing you will arrest him. He is in your custody. Custody doesn't mean he has to be in your hazard. Once you get hold of a person and restrict his liberty according to law, then he is in your custody. So anyone else on 27 or any clarification you will need? I'm not saying don't make it on writing. Usually make it on writing. But if the circumstances demand you have no time for that, then that would be sufficient. Instead of calling witnesses later on and breaking your case, stay true to what you have done. If you have no option, if you have options, yes, you can make the document. If you have a belief on that witnesses, whom you think that will say truth in the court, because you will know when you are even if 27 statement got at the top as witness, you will be knowing who will speak there in court truth and who will not. Right? Anyone else on 27? Yes, sir. After
he was arrested, then he told me that this thing is out there. त्यो उनीहरूको साइडमै छ भने हो अन्त त्यसको बाद हामीले सबै रिकभर गरिसक्यो डगहरू त्यो डेड बडी अफ डग हेड बिन रिकभर्ड त्यसको बाद विटनेस बोलाएर आई मेड द डकुमेन्ट्स इन द स्टेसन ओन्ली आफ्टर द्याट वी वेन्ट टु रिकभर द्याट रिकभरीको त्यो गएको त्यति बेला चाहिँ त्यो रम्बा चाहिँ उनीहरूले पुरै युज गरिसकेको थियो त्यसमा केही उयो नै थिएन ब्लड स्टेनहरू पाउने कि फर स्याम्पलहरू पाउने कि चान्सेसै थिएन र पनि त्यतिकै रिकभर गरेँ बट आई डोन्ट नो हाउ त्यसको भ्याल्यु कति हुन्छ किनभने I could not say it for forensic also because blood stain 3 days बाद recovery भएको अन्त पुरै उयो भइसक्यो थियो युज भइसक्यो थियो हो त्यतिकै रिकभरीमा त्यतिकै लिएर चाहिँ मैले त्यतिकै केस
As I said to you earlier, it is one part of a weak evidence recovery. You must have some other things, right? So what he said is, talked about blood stains, right? Okay, that is also an evidence. Now what usually police officers do is, someone just like him, if there was blood stain, let's suppose, okay, what some police officers do is, they recovered. The discovery more concrete. Discover उसको statement में भयो, जुन चाहिँ blood stains थियो, suppose you have to match गर्दैछ अरे victims सँग, then it's more strong, no? Court will more believe, यसले भनेर गर्यो. But if you have just यसले भनेर पाएको मात्रै हो, which usually witnesses will turn aside. When witnesses आउँछ तपाईहरुको कोर्टमा, मलाई त के याद छैन यसैको सही गर्नु भने मैले सही गर्थे मात्रै भन्छ. Usually in a hurry that happens also, because if you call witnesses and say that do this process, some may not agree. So what police officer case त सक्नु पर्यो. सही मात्रै गरिदिनुस् न भन्थ्यो पनि ट्रु पनि हो. Most of the witnesses what they say. So 27 discover भएपछि examine that what you have discovered, whether it can lead you to some more other evidence, and don't just leave it there, seal it, close it and bring. And otherwise, but suppose blood stain हुनु भने वा कोर्ट बिलको त्यो blood stain थियो examine गरेन किन गरेन, okay? So those things you have to keep in mind. Now one more thing, as you said, that it's actually a confession, right? But only that part is being used. Only that is admissible, which leads to a distinct discovery of a fact. It should be distinct. Now there are many aspects in 27 also. Suppose, let's say, in the Ramba भने, त्यो Ramba चाहिँ गोठमा छ भने, गोठमा अरू पनि Ramba है, अरू पनि तपाईको agricultural work गर्ने instrumentहरू राखेको छ भने, it is again very weak bias. Because what it says distinctly, यस्तो चीज हुनु पर्यो which you police could not find it ordinarily. Because what you are doing is, यसले भने यहाँ फ्याकेको छ, गयो यसको स्टेटमेन्टमा निकाल्यो. That is usually weak. कोर्टले जग्गा हेर्छ, कहाँबाट रिकभर भयो? If it was on the roadside, which you could have ordinarily found without his statement, then 27 is weak. That is why I am telling to you all, 27 says it's a last resort. Statement छ भने राख्नु, तर अरू चीजमै believe. If you have yourself, what some police do is, which gets disclosed during the trial, is that you have found the object without accused saying. Now you come back to police station, make a statement of accused, which he says, यस्तो यस्तो मैले यस्तो गरेँ यहाँ फ्याकेको. तपाईले अघि पाइसक्यो नि त्यो, पर्दैन 27. But believe me, your superior will say, if you submit a charge sheet without 27, where is 27? बनाएर ल्याउ भन्छ. So when all these things come in the court, no, जब कुरा मिल्नु छोड्छ, then the doubt comes into the case and prosecution failed to, which you famous word which you know, prosecution failed to prove the case beyond reasonable doubt. भनेर कोर्टले अखेट गर्छ. अब घर भित्रै तपाईहरु पिओ मा गयो, पिओमा जाँदै हतियार चलाएको त्यहीँभित्र चुलाको छेउमा तपाईँले भेटिहाल्यो, किन चाहियो 27? चाहिएन. You can say I found this out and seized it. But usually statement पर्नुपर्छ. Now what will say, I had one case where that had happened. I found that पुलिसले देख्ने जग्गामा सामान चाहिँ किन 27 चाहियो. 27 is not that the court will believe the version of the accused. That's inadmissible. What court will believe is what you found on his statement, which ordinarily you could not have found without the accused telling you. That is the purpose of 27. So if that requirement is there, you have to do 27. If that is not there, you yourself is recovering the evidence, just keep a Caesar witness and this. If someone asks you why you did not do 27, court will never ask this. If somebody superior asks you, when I went there, I found it, I seized it. Though it's easier said than done, for you all it will be difficult, but still I am telling that no need to make 27 once you have found the object. It becomes useless. So another aspect of 20 confession to a police officer, can it be admissible in any other circumstance? I said only districtly that part can be admitted. Admission हुन्छ पुलिसलाई डाइरेक्ट भनेको अरू भर्सन पनि सिचुएसन छ त्यस्तो कुनै, which is I have never seen being used by police officer till date. At least मेरो jurisdiction मा सिक्किममा मैले देखेँ. If you can type one section. Section 26, Indian Evidence Act. I read it, no confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. So I have never seen a police officer recording confession in the presence of a magistrate. Right? Executive magistrate. Judicial magistrate will not go, because they will have to do the trial and they usually don't go to police stations. It can be used to prove against the accused. Section 26 says that. यहाँबाट यहाँ कनेक्ट छैन. We need that. You can pick that board up. And you can Google it and see. C26. Sections on how you can use that. You can show him before the magistrate and say, record his confession. He might say. Though usually, they don't say, but there is a chance. Very rarely. You will come very fast with the 164 statement of witnesses. But you will rarely come with the confession of the accused. It may not work 60% of the time, but it may work 40% of the time. If you really feel that this person is remorseful, sano offense ma remorse hunda, no thief will say, I am remorsing of what I did. Murder cases ma people after killing it, some do get very remorseful. I did it wrong. It's a huge offense. Your life is over. So in such cases, you can sponsor confession before a magistrate, judicial magistrate. 27 exception मात्रै हो अरु provision को है. 26 मा हेर्नुहुन्छ भने magistrate को presence मा गरेको confession can be proved भन्छ. 27 मा
हैन. यो मोटर वेपन हामीले सिज गर्यो. त्यसमा चाहिँ मान्छेको भिक्टिमको ब्लड स्टेन्स छ. तर एक्युज को हो अब हसियामा चाहिँ प्रायः जस्तो फिङ्गरप्रिन्ट्सहरु बस्दैन छ. हैन हसियामा चाहिँ फिङ्गरप्रिन्ट्स छैन तर वी नो दैट इज मोटर वेपन. अनि त्यसलाई त्यो वेपनलाई चाहिँ त्यो एक्युजसँग टाइप गर्नको लागि वी डोन्ट ह्याभ फिङ्गरप्रिन्ट्स अर एनीथिङ. वी जस्ट नो दैट दिस वेपन वाज युज्ड टु किल दैट पर्सन. अनि सपोज त्यसको छ एउटा सिनेरियो त्यो भयो. नेक्स्ट सिनेरियोमा चाहिँ त्यो मान्छेले डिस्कभर गर्यो. हामी डिस्क्लोजर गरेर चाहिँ यो वेपन चाहिँ यहाँ राखेको छु भने त्यसमा चाहिँ अब डिस्क्लोजर भएर चाहिँ त्यसमा त्यही ब्लड स्टेन मात्रै भेटायो, फिङ्गरप्रिन्ट भेटायो. सो त्यो दुईटा केसमा त त्यो रिकभरीको बेसी भ्याल्यु हुन्छ.
जुन चाहिँ तपाईले सेकेन्ड एक्जाम्पल भन्नु यो मिनिङ अफ एक्चुअल रिकभरी अर पोस्ट रिकभरी विच यु मेड इट.
हैन हामी सपोज दुईटै सिनेरियोमा अब एउटा सपोज ती भेटेको छ अरे हो, त्यसले भनेर भेट्यो तर हामीले त्यसलाई रिकभरी गरेन हो, नेक्स्टमा चाहिँ हामीले त्यो रिकभरी गरेरै भेट्यो।
उसले भनेरै भेटेको फर्स्टको इक्जाम्पलमा
साइडमै छ, सपोज साइडमै छ, त्यति बेला हामीले देखेन रहेछ होइन त्यो उयो गर्दाखेरि, तर उसले भने त्यति बेला
that can be
रिकभरीमै बेसी उयो आयो त्यसमा।
that can be done as a recovery, okay, because यस्तो छ नि तपाईँ देखेन भन्नुभयो नि, once you go to the investigation scene, you look everything, जति पनि humanly possible छ, you will examine that scene, right? So there will be very rare circumstances which you are saying तीनरी थियो हामीले देखेन अफिसले, that's very rare. That may not happen, okay, that can only happen if you are not careful. So that situation should not arise, which example you give. Second ma tapai jun cha, that's why I'm saying, no, if it's an actual recovery, it does have a value. But once you force the herscha ni later on, they scene ta examine गरेर फर्किन्छ नि तपाईले. So it is not such a place that you would require the statement of accused to get that. Of course, even before you ask him, if he says, okay, then you can bring it as a fact, accused said and I got it out there. You know, तपाईले यसमा 27 नै बनायो भने पनि suppose ती भएको चिजको लागि it's very weak. So court will hardly rely on that. Even if it's a truth, even if the accused said to you first, I kept there without asking. उसकै डिस्क्लोजरमा आयो, भेट्यो तपाईले मौकै पाएन नि त खोज्ने, उसले भनिहाल्यो भेटिहाल्यो. You can bring that as a truth also. Why to make it 27? त्यति heavy strong हुँदैन, because it was just there. Court will disbelieve you. अरे तीको चीज, how come this police officer couldn't get, and he is saying he got it on the basis of the accused disclosure and he made a disclosure in the witnesses, right? You can simply say yes, you can give the truth. Accused spoke it, I found it out there and I seized. Okay, मैले अघि भनिहाल्नु नि त राइटिङमा हुनुपर्छ भन्ने छैन नि त. अक्युजले डिस्क्लोज गर्यो, that's why you found it. It is still falling under 27. You can say either this was the truth, or you can say, you know, it can be considered as a 27 recovery also, not statement. I would not say 27 statement, I would say 27 discovery. Any confusion, right? Ask if you are confused. Get confused with my answer also. 27 मा अरू कसैको छैन, उहाँले अघि
एकजनालाई चाहिँ हामीले पक्रेको छ रहेछ, उसले अगर बादमा डिस्क्लोज गर्दैछ कि मसँग अर्को कुनै कम्प्लिस थियो अरे भनेर.
भेरी गुड क्वेसन.
अनि त्यो टाइममा पनि हामीले यो अन्डर 27 नै त्यो गर्न सक्छ नि होइन. मतलब फर द्याट अल्सो वी निड विटनेसेस. अर नर्मली हामीलाई जुनले कन्फेस गर्यो भनेर पनि
बुझेन मैले.
सो जस्तै अब 27मा कुनै पनि नयाँ फ्याक्ट या फेरि कुनै पनि नयाँ उसको लागि भन्नु पऱ्यो नि त. जस्तै कसै अघि पनि भन्नुभयो तपाईँले, अब त्यो सिन अफ क्राइममै उसले भन्दैछ देयर वाज समन जसले चाहिँ त्यो सुन्दै थियो भनेर. अनि अब यसको लागि पनि अब उसले भनेर बादमा अब कस्टडीमा हुँदाखेरि कि यस्तो यस्तो थियो, मैले अर्को पनि एकजना मान्छे थियो भनेर डिस्क्लोज गर्दैछ अरे, त्यसलाई पनि हामीले 27 नै अन्डरमा कन्सिडर गर्न सक्छौँ.
मतलब he said two things at two different times भन्नुभएको.
हजुर होइन सर, पहिला त लिएर आयो, हामीलाई याद थिएन कि अर्को मान्छे पनि छ भनेर.
Involved in as an accused.
बादमा अब अक्युजको हामीले उयो गर्दाखेरि चाहिँ उसले डिस्क्लोज गर्यो कि यस त्यो अर्को मान्छे पनि थियो मसँग.
Actually, this usually happens in drugs cases. NDPS section 67. मेरो माइन्डमा आइहाल्यो, that's why I'm going to NDPS also. So this is for that. Also ट्याबमा section 38. What section 30 says is, when more persons than one are being tried jointly for the same offense, and a confession made by one such person affecting himself and some other of such person is proved, the court may take into consideration such confession as against such other person, as well as against the person who makes such confession. Now, यसमा judicial pronouncements are a bit confusing, sir. But my view is section 30 is only about confession made to a magistrate. My belief, my understanding of law is when an accused tells this person is also involved in murder, what usually police officers do is, because I was very harsh during remands on this, I did not allow remands when a next person was produced just on the basis of someone's, what the other one said is inadmissible. We will not look at it. So trial को stage आको हुँदैन, तर भए त्यसको भ्याल्यु छैन नि त. Right? That is one thing. Now once the person says he is also involved, you can ask him what role he played. उसको पनि केही सबुत त होला नि त. And you also, instead of arresting that person directly, should find out some evidence. Of course, power to arrest is your power, no one can stop you. But once you bring for remand, you will be again in thick soup. How will you convince a magistrate that this man is also involved? अर्को कागजमा त एफआईआर भेट्यो होला, केही स्टेटमेन्ट आयो है, उसको त अफिसको स्टेटमेन्ट मात्रै छ. Let's take a simple example I'll give. How, I'm just being practical, okay? How we all deal things. When we are pushed to the corner, we look at the law. Let's take a simple example. It's my experience, okay? You all are still growing in this investigation. Why that does not happen with everyone? That I never understand. Usually we see offences in the lower strata. People, actually I don't like to classify this strata, but I'm just trying to make you understand what I'm trying to say. You know, people are divided economically, right? And usually offences we see in the those people who are economically weak. In villages, my understanding is that people, they live life just for one day. They don't think about tomorrow like we do. We have great plans. This salary is coming next month, I'll do this, that. People in the villages don't have plans. And all these things as of now, we are still not that modern in law also, I would say. Yes, we have grown as a society, very modern, but laws are still archaic, old laws, So it does not match. Whatever it may be, even if you see in Gangtok, which I used to visit, the most worst treated under trial prisoners are the drug offenders. Their cell is such a small one, cramped. In rainy season, all rain pours out there. Inside is all wet. In one bed, at least 3 people sleep out there. And so why I am saying all this is, the arrest also is sometimes done by looking into, usually it is done. What would be the reaction of that person? Whether, you can arrest him easily and nothing would happen. So that's why I'm saying, in law, someone confessing that he also did it is a good thing. He gave you something, it could be a fact. You have to act on that. But you must have evidence against that person also. Otherwise, suppose someone names, let's say you are investigating, someone randomly names him, a police officer, he was also there. Will you go and arrest him? Suppose that person names some ordinary person whom you don't know. Will you go and arrest him? Yes, there's likelihood. Why not arrest him, your colleague? Statement is same. He was involved. Why not? What plays in your mind?
Because I know him.
You know him. You have a belief that he would not do that. But would that really make a difference with the other person also? Why you don't have that belief for him? My point is, in law, so you are actually not acting according to law. You are acting more according to your senses, right? So what I am pointing out is a confession made by a co-accused, right? If it is a confession made before a magistrate, judicial confession, okay, or even an extrajudicial confession. Extrajudicial confessions are those confessions which is neither made to a judge nor to a police officer but to any other person. Okay. And that person comes and says to you, yes, he was also involved, you have a ground of arrest. Because for arrest, you will only need a reasonable suspicion. You must have a reasonable suspicion to arrest someone. A reasonable, at least suspicion bhai pani hunu parcha, and your suspicion must have some ground to rely on. You just can't suspect anyone. Suppose if the magistrates ask you why you are suspecting this person, you must say these are my reasons for suspecting. And it could be a very small reason also. The court would not be bothered by that. But the court will definitely see whether you have a reason to suspect that person. Now, moment if you come and say, who accused said it, the court will agree with it. But yes, if you have a judicial confession, just like a confession, which is a record person, you can close your eyes, go and arrest. There is no problem. Of course, in those offences where arrest is permissible, without going back to Ernest Kumar. Okay. and in extrajudicial also. But I'll give you one exception to this, which is being usually done in NDPS cases, but police are not aware of what is that.
The government may, during the course of any inquiry in connection with the contravention of any provision of this Act, call for information from any person for the purpose of satisfying himself whether there has been any contravention of the provision of this Act or any rule or order made thereunder. B. Require any person to produce or deliver any document or thing useful or relevant to the inquiry. C. Examine any person acquainted with the facts and circumstances of the case.
So in NDPS cases, this is the section where you can arrest the co-accused on the version of the another person. See, it says because in CRPC there is no provision where a confession of an accused, with the help of a confession of an accused, you can arrest someone else. There is no provision. But in NDPS there is. Any officer referred to in section 42, the state government has many other sub-inspectors are empowered under this Act by the state government. Call for information from any person. It neither says accused nor witnesses. Okay. So there is a substantive section out there in NDPS because actually it's only in Sikkim I haven't seen. In all other states, statement of accused is recorded under section 67 in NDPS Act. SJA does not have a similar provision. I know this statement has a value, but what usually recorded is 27. What you discovered in 27? Nothing. Okay, even if that person said, okay, from now, there could be one aspect, another aspect to this. If that accused said, yes, he sold me, you go and you find something in his house, the drugs which he was involved, then you have a ground to arrest. But if you find nothing, and the whole purpose of NDPS and SJA is that you must find some contraband substance in that person. If you don't find, there is no case at all. Okay? Consumption ko huna sakcha, but for that also you need some medical proof. So unless you have some evidence against the other person, you cannot arrest or proceed against him without some other evidence apart from that confession. But in NDPS, because of this section, mere some person saying is sufficient. You have examined any person acquainted with the fact. You have examined, he has said, he was involved, so what, I arrested him. Right. So under this, it can be done in NDPS. In all other states, police rely heavily on this section 67 statement in NDPS cases. But not here, I have not seen. You can go and study this NDPS, you can Google गरे पनि NDPS को यो section 67 केस कति आउँछ हुन्छ. So this is regarding the confessions. Now next we can move on to 64B. 64B anyone has done? 65B, sorry. That's it.
सर मेरो एक्सिडेन्ट केस कुरा आएको थियो एक्सिडेन्ट केस हुँदा मैले स्मार्ट सिटीमा गएँ सर स्मार्ट सिटीमा गएर त्यहाँ रुरल अफिसरमा 65B सर्टिफिकेट मागेर चाहिँ
हैन किन जानु के कारण छ होला
त्यो सर एउटा भिडियो क्याप्चर भएको थियो त्यो भिडियोको चाहिँ भिडियोलाई पनि सिज गरेर र 65B पनि मागेर चाहिँ लागा
ठिकै छ है अफिसर लेभलमा है यस्तोमा इट्स अल राइट. Now 65B is mandatory or not?
Yes.
Honest?
Second.
No, they're absolutely wrong with this. You guys also saying yes? Who thinks that 65B is a secondary evidence? I think it would be better if I go to primary and secondary.
I didn't put 65B in that POXO cases, photographs of POXO cases which I have taken.
It's inadmissible.
But sir, in case in PS, I was there for 2 months. They asked me to put 65B.
Yes, they were absolutely correct.
So, which procedure is correct?
What Gazing said is correct.
The photographs we have to put in
Yes.
that. Whatever pictures we have clicked in.
Whatever is digital output, there must be 65B.
That means whatever cases I have submitted in that other PS,
No, it depends on how relevant were the photographs for that case. Okay, because photographs are rarely used to convict a person. If you have other evidence, it's all right. Photograph ma ke luga huncha, jagako naksha huncha. It's not required actually. I hardly see photographs. I hardly used to see. It has to be. Sometimes I ignored, we look into the case. If it's case going towards the conviction, then I have to be strict with the procedure. If it's already acquittal, then they exhibit photograph, I just keep silent, because one primary reason was the digital outputs were not proved. All ledgers digital and but a print was STDC case there, and not STDC from two distilleries, some all that good. I cannot even look at it once it is inadmissible, right? It may be having very incriminating evidence. I as a judge would not be bothered because I would be sticking to law. Right, so 65B is mandatory. Now photograph because Alex छैन अहिले बहुतलाई मेरो मैले पनि ignore गरेको, but when it really comes to writing judgment and if the photographs are relevant, then I will comment there is no 65B. Then because of which I am not looking into it. Actually, to be frank, the investigation requires huge, support. See, in law and order, you will do get all kinds of supports. You are posted there. You will do well also. But when it comes to investigation, you don't have the, the instruments, the forensic team. Hopefully it will improve one day, right? I think the DNA test is being done in RFSL, right? What does it? Huh? What are the opening गरेको भन्थे त?
So instrument मात्रै ल्याएको छ. Start भएको छ.
Okay. So see, I think we are improving. I don't know. I always had in mind why that place does not have. It takes 2 years to come from outside. Sometimes it doesn't come in 2 years also. So I don't know from forensic team. So strong, but about camera. Actually, why is 65B required? And can anyone tell? I think partly what you said, okay, you were saying something was...
But that's the second, 65B is required.
Why?
Because phone produce direct evidence.
Okay. In that context, you are true. I thought that earlier what you said was, you were saying that 65B is secondary evidence. I was saying no. Okay. It is just a certificate which is supporting some kind of secondary evidence. So if you meant that, you are absolutely correct, and you also.
Sir, मैले एउटा सुनेको जस्तै अहिले चाहिँ थानातिर पनि एउटा क्यामेरा हुनुपर्छ रे तर युजुअली
थानातिर भने तपाईको कस्टडी जहाँ इन्टरोगेसन गर्छ नि त्यहाँ हुनुपर्छ. इट्स अ म्यान्डेटरी सुप्रिम कोर्ट जजमेन्ट समटाइम्स विच कुनै दिन केही दशा बिग्रेको छ भने सम अफ द हेड्स विल बी इन ट्रबल फ्रम एट दि हाई कोर्ट लेभल.
सर क्यामेरा त्यो चाहिँ लाग्छ जुन चाहिँ त्यो हामीले फिल्डतिर बोकेर जान्छ नि सर जस्तै पिओहरू खिच्नु जाँदाखेरि त्यसको लागि चाहिँ हाम्रोमा अहिले त्यस्तो कतिवटा ठाउँमा छैन सर तर स्मार्टफोनले खिच्दाखेरि यसमा पनि हाल्नै पर्छ हेर्नु सर 65B छ
पर्छ नि तपाईँको स्मार्टफोनमा खिचिसकेपछि त्यो एभिडेन्स भयो. Anything digital, electronic. Whenever electronic comes in your hand, 65B should come to your mind. Okay, phone the device though they'll extract the memory but so phone ल्याउँदा चाहिँ नचाहिने 65B content the memory ma chha. Moment you take out memory card and then you need 65B. So I don't see any logic in it. It's actually if you look at the history of 65B, it's a troublesome. Now when 65B came in the year 2000, त्यति बेला न त स्मार्टफोन सबैकोमा थियो भर्खर भर्खर आएको थियो होला हाम्रो देशमा है. CCTV भन्ने कहीँ थिएन, यस्तो भिडियो सिस्टम थिएन, कसैले भिडियो खिच्दैन. Actually 65B was made in the official context. Because out there the 65B, what it says, who can give the certificate? Someone occupying official position भन्छ 65B. अब त्यो घरको CCTV मा official position पुरै आउँदैन. So the law has not changed actually. There are provisions that so it had to be given effect given by the judgments of Honorable Supreme Court. So they have tried to give the effect to the provision. But what I feel actual intent of the framers when they made it, they had not foreseen CCTV, mobile cameras in everyone's hand. Okay, they have not foreseen this. They only thought that electronic evidence would come out from the computers, which has changed now. So the law is still not developed with the changing time. There must be something. It's really a troublesome, that. Or you must every time police station at least should have 10 cameras to avoid 65p. One IO uses one, he submits in the court. Now that might come after 1 year, 1.5 years or 2 years. Someone will have to again seek its release. Right? So to avoid all these things, 65B has to be there. Now 65B ma tapaharuko euta problem chai ke aउँछ भन्दाखेरि 65B is a certificate. Someone is saying त्यसको contents like ठीक हो भन्दैछ नि त. The signatory down there, whoever issued it. But what I have seen is one question demolishes everything. Crossमा उसलाई सोधिदिन्छ कि यहाँ के लेखेको छ याद छ? याद छैन भन्छ. Certificate value is gone. होइन. Someone who certifies something has to know what he is certifying. The moment that person says, I don't know anything written out there, then 65B is gone. The moment that certificate is gone, the judge will not look into them. He couldn't rely the certificate only. So it's a problematic provision actually. Not all people know that. If you read 65B, the contents, even will not understand. There may be no one in the house. Someone else might be doing, and police officers are getting from someone else. That is also correct. Someone who manages that device, maintains it. That is also alright. But someone in the house might say that yes, I manage it, but he doesn't know anything about computer. अब CCTV लगाएको छ, कोही बेला त्यो यताउति घुमाउनु हैन, अलिअलि कम्प्युटरमा आएको छ कि छैन भिडियो त्यो हेर्न त सक्छ नि त नर्मल मान्छेले, तर उसलाई ज्ञान त छैन नि त्यहाँबाट कसरी ट्रान्सफर हुँदैछ, के मेकानिजम युज हुँदैछ, इट डजन्ट नो. So you obviously come and say in the court, I do not know what is written on it. So it's a problematic provision. I do not know how we will come out of it. So even, there was a case that you could see in CCTV how many times you complained, right? I had to acquit him because there was no 65. Now I felt what the accused might have thought towards me, towards the judge also. He saw everything, still he says I am innocent. Accused might have thought, he might have laughed at me on the behind because he doesn't know the law, right? So these things can happen. I have acquitted a thief despite seeing him in CCTV, not only once, more than twice or thrice, in three or four cases I had to acquit because there is no 65. Now another thing about 65B is you can bring it at any moment during trial. If you have forgotten to bring 65B, but you have given the evidence, electronic, you can bring it at any time during the trial. You have to pray to the magistrate. There is a judgment of Supreme Court. Now, I don't want to burden you with judgment. That's the job of PP to help you. Right? Do it. Any time before the judgment is pronounced. There is no bar to it. Of course, यसमा चाहिँ अब अलिकति प्रब्लम चाहिँ के हुन सक्छ भने कोही बेला CCTV मात्रै हुन्छ एभिडेन्स. जस्तै मेरोमा एउटा चोरीकै केस थियो. हेरिङ अन चार्जको स्टेजमा आई एम सेइङ 65B जहिले ल्याउँदा पनि हुन्छ, राइट? हेरिङ अन चार्जको स्टेज आयो. अब चार्जमा पुलिसको रिलायन्स छ, CCTVमा देखेको छ मान्छेलाई. मैले चार्जको हो कि होइन भन्दा त हेर्नु पर्यो नि त. विदाउट 65B आई कान्ट सी ओन्ली. सो इनिसियलीदेखि छैन भने चाहिँ प्रब्लम हुनसक्छ. अब अरू एभिडेन्स छ भन्दा जसले चार्ज फ्रेम गरिदिन्छ अरू एभिडेन्सहरू र CCTV बादमा हेर्छ. तर त्यही मात्रै सोल एभिडेन्स हुँदा त फ्रेमिङ चार्जको स्टेजमा पनि जसले हेर्नु पर्यो नि त हो कि होइन पुलिसले भनेको कुरा ठिक हो कि होइन. 65B छैन भने त्यही बेला नै हेर्नु सक्दैन जसले. सो केस डिस्चार्ज हुने डर हुन्छ. If you have other evidences, there is no problem. But if that is your sole evidence, the case might get discharged because judge they believe गर्नलाई हेर्नु पर्यो नि त CCTV. फ्रेमिङ अफ चार्जको स्टेजमा पनि. Okay, so त्यो प्रब्लम हुनसक्छ. Otherwise, even if you have forgotten, if some inadvertently it was not brought, you can bring it at the any stage of trial. PP has to file an application to the magistrate, praying for permission to bring. There will be huge objection from the other side, but don't worry, there is a judgment which says you can bring. It's just a certificate, it can be brought anytime. Yes, photograph को बारे में याद हो. अब technically कोई है भने photograph में पनि चाहिन्छ. Probably, त्यसमा who will give the certificate? SHO or अध्यायो
The one who is just
kitchen. There's confusion regarding just keep it with yourself, don't complicate it. I also find another complication in this, which I'm just telling. That a camera is also a device, a computer is also a device. You know, if you are bringing it through the in a CD, then you have burn a CD in a computer. Computer is also an electronic. Can you just do with the 65B of camera, or you need one more certificate?
computer like
So what at present it has been done is only computer composition, which courts are accepting. Camera पाउँदैन. Some माथि कति लेखेको हुन्छ है, यो क्यामेरा यस्तो यस्तो, but only one certificate is it's sometimes. But if you really have to do what the law is saying, मलाई दुईटै चाहिन्छ जस्तो लाग्छ. क्यामेराको पनि त्यसको, because both are digital, both have worked independently to produce that output. Okay, because though the section says produced by a computer or by a combination of computers. Okay. Because of this, you may be able to improve the camera engine. But when that certificate is coming, I think at least it should be mentioned both devices should be mentioned. Okay. The computer camera is not really a computer, but digital cameras can be said to a certain extent to be a computer. It processes images. Anything which processes becomes a computer. Because computer, computer itself is a word, which means the device is computing something. Right? Even a calculator computes something, but since it's not electronically computing, it may not fall on a computer. But all those digital devices, the watches which we have, the phone, are computers. By its very broad definition. So yes, 65B is mandatory. It can be brought at any time during trial if you have inadvertently missed it out. Okay, but if that has been done, try to bring it at the earliest. Because the court will not look at that evidence unless you bring the certificate. Okay? So any questions on this? I don't know if anyone has that comment. At present I don't remember, let's be wrong. Because Gazingma the case is completed, I did dealt with cases. Gangtok there were a lot of cases.
Sir.
It's been 3 years I've read Gangtok, so for that format, I did used to find sometimes a flaw. I don't remember what was it.
That is this from the weighing machine.
What output is it giving? Is it giving any output?
It gives the weight. जुन चाहिँ अब डिजिटली दिन्छ सर त्यो सानो खालको होइन
वेइङ मसिन सानो सिम्बो खानु
Then I've not dealt. Let's see 60/3 ones. मलाई पर्छ जस्तो लाग्यो तपाईको क्वेशन्स. कोर्टले मागेको छैन नि अझ हैन. Admissibility of electronic 160% statement work. Computer बाट निकाल्नु we have to use 60/3 then. So computer output we have typed in computer. It's not required. Now one person pointed me this question मैले पनि एउटा ट्रेनिङमा अब जुन क्वेशन गर्नुभयो यसको आन्सर चाहिँ मान्छेले के देख्यो भने इट्स इलेक्ट्रोनिक रेकर्ड्स. That must be some kind of a record which can be kept as a record or for that weighing it, the output कसैले पर्सिभ गरेर चाहिँ लेख्दैछ नि. Okay. For that I don't think it's required. I'm using my common sense and my understanding of law so far to say it's not required. Okay, one has to do a very deep study again to think that whether it's required. But based on the law so far, the logic, I think it's not required. Any court insisted, why this court?
अब any digital evidence हुन्छ नि सबले अनि त्यो पनि अब डिजिटली नै दिएको उयो हो सर हैन evidence के भन्छ
contraband substances को weight दिएको हुन्छ and based on that weight
Okay, let's see once. मलाई चाहिँ अझै पनि पर्दैन जस्तो लाग्छ.
सर जेनरली हामीले बरोबर बेसी कम्ती हुन्छ जुन चाहिँ वेट सेभिङ अफिसरले सिज गरेको छ
This किन भएको everywhere it's at.
यति बेला चाहिँ क्वेसन चाहिँ
How does it happen?
सब्सटेन्सिभिटी जुन हाम्रो प्रेस हुँदाखेरि त्यो वेट हुन्छ सर त्यो गिलो खालको हुन्छ त्यो कोटमा राख्दा सुक्दैन नि चिसो बादमा चाहिँ ड्राई एकदम डस्ट.
Then you must mention that while writing the charge sheet. Weight, it's weight at the time of discussion of this. Now what had happened in gazing was one thing, because small quantity is bailable and triable by magistrate. Large and commercial quantity is non-bailable and triable by sessions court, special court. What had happened with gazing was machine by. I think you were doing carriage, but you unit change was the one it makes 15 or something. So be careful of that also. I don't think that is required because I think the answer is here only. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer shall be deemed to be a document if the conditions mentioned. So see, it's not required. Electronic which is printed on a paper. Is that printed on a 100% sure on this? Someone is seeing and writing it down. Otherwise, let's say, for example, what it could be. Because you'll have to bring the CCTV. Court may still want to look at the weighing machine, what it can, but that's impossible. The batteries of some also. It's not required. It's not either printed on paper, neither transferred to any optical device. Neither it is a record which you are bringing itself. So whenever just like CCTV को CD मा कन्भर्ट गरेको हुन्छ, क्यामेराको फोटो प्रिन्ट गरेको हुन्छ हैन, यसको के गर्नु? म्याजिस्ट्रेटले यति ग्राम देख्यो भन्दै हुन्छ, पुलिसले सिजर मेमोमा दिएको हुन्छ. But still it's something which has to be followed. All cases are 65 people. But के हुन सक्छ भन्दाखेरि चाहिँ अक्युजले भनेर डिस्कभर गरेको घरिघरि उसले भन्दैछ भने डिस्कभरी भए पनि some kind of doubt might come that you may have induced him something. Okay? Because the job of defense is they will try to do this. But in law there is no bar. My only suggestion to you is be true to what facts you are giving. Don't try to make here and there and law को लाइनमा हाल्ने ट्राई गर्नु भन्दा चाहिँ of course sometimes it is required because absolute जुन mandatory provision छ त्यसलाई तपाईले गर्नै पर्यो बनाएर भए पनि तर जुनमा त्यस्तो छैन नि तपाईको जे फ्याक्ट त्यही हाल्ने कुरा हो मेरो अनुसार the court will believe more that rather than your forced facts which will ultimately come. There is no bar in law, there is no bar because today accused might say मैले यसलाई घुरेर हिर्काएँ भोलिपल्ट आएर होइन मैले यसको घाँटी पनि बटारेको थिएँ. Obviously you can do it, right? You didn't say that yesterday. Your thing will be as an IO. You didn't say yesterday, that's why I did it. But while writing charge sheet, please write all these things. What usually format comes is, suppose, who told you, how you reach there, because though what you are saying is there, what that is the charge sheet, because when one charge sheet is what at the time of charge sheet primary facing. So at that time, just read oh, this has a case in it. So if just in a case you have said that there is another disclosure, usually it's not written in charge sheet. And if you ask me in law, there is no bar in reporting. See, natural 27 state. Why do I say natural? Occurred fact. Not you force something. Complementary charge sheet is 178. Now 32. 32 कसैले गर्नु भएको छ? Time impression. So
requisition चाहिँ पठाएको छ त्यो.
Doctors you can record, but not as I would suggest. But yes, if you have no option, the person is about to die and he said something and you write it. There's no bar in not calling that a language. What else could you have done? Could you have called the doctor? Could you have called the magistrate? No, you was the only person present there. So you wrote it. for sake, right? There are many cases where police constables have recorded, police officers have recorded. But the thing is, that will be a little bit suspect. Because if you routinely allow that, then every time police officer will write and make themselves. Because you have to make your case, right? Believe me, in Indian legal jurisprudence, you all will always be doubted. So, that's the legal system. So, anyone can record that time declaration. Of course, by anyone I do not mean any people just coming there, and there must be some occasion for him to be there and record it. Okay, usually go with magistrates. That's the best option. Doctors are also one of the options. Sometimes magistrates are not available. The nearest person is doctor. And you also can do it, but in exceptional circumstances and other persons. And in dying declaration, keep one thing in mind: what comes as a statement. Once I had a dying declaration, the case was FIR on the murder, but it was FIR on the previous one. Okay, because there being no intent to kill someone. And then it has to be in the first person, the language, what the person is saying. More you about less you. That is more like it. Now, if someone else is writing in the another version, translate that is not his version. That is, he is interpreting what he is saying. That value is lost now. Meaning. So it has to be. Usually it's in a question answer form when it's done by the magistrate or the doctors. More by the magistrate. So this is the question, this is what he said. This is the question, this is what he said. Right? Sometimes if he keeps on going, then ordinarily it has to be in the first person language. And what he spoke, rather than what I am understanding and teaching. But you cannot control this usually. That is, person who is recording has to be careful about that. Because this dying declaration, 32 is a big section, it's not one part of your dying declaration. When the statement is made by a person to the cause of his death, or as to any of the circumstances of the transaction which resulted in his death. So in both death are important. Death has to occur. In cases in which the cause of the person's death comes into question. Okay, only in those cases where it's a question of fact to be determined whether what is the cause of his death. And it is usually said that a person has to be expecting death while making it. That is correct in English law, but not in English. Okay. Though that is one of the factors. Why dying declaration is accepted? Because the person has already died. The court has no one to listen to. It has to rely on statement made by him. Someone coming and saying is made by him. Also, त्यसले गर्दा यो चाहिँ प्यारामिटर्स हो. अब कोही मान्छे मर्नु आँटेको छ, यसले चाहिँ ढाक्दैन नि त मर्ने बेलामा भन्ने चाहिँ एउटा रिजनले गर्दा हो. Okay, let's accept his death. No one would falsely implicate someone or say something wrong or lie it at the deathbed. One एउटा moral acceptance. That could still be wrong in law. मर्ने बेलामा आफूलाई फसाइदिएर गएको पनि हुनसक्छ. We don't know. How can we have a general moral acceptability for everyone? We can't have. Depends on person. हामीलाई आफ्नै morality त बुझ्न साह्रो पर्छ. Or of friends. Everyone have different beliefs. Someone may feel that, he might reflect upon his life and feel that, someone I lie today and put this person. It's a possibility. So that is why it is said that, in English law they say that a person has to be expecting death. Usually I have seen, you all don't rush to record dying declaration when someone just hand is cut. I have seen cases. I don't know why I feel some superiors go and report. And sometimes in accident cases also, usually first either ASI goes, or the junior most SI is sent for inquiry, or some constable is sent. And he writes of the dying declaration because the person has injuries. Dying declaration is a situation back over. You just don't go and say, मान्छे त मर्ने जस्तो छैन, but you still record time difference. That's wrong. It's valueless. Why to waste time? So don't be this routine. I always you. Sometimes तपाईलाई यस्तो पनि भएको हुन्छ, यो मान्छे त मर्दैन, गर्दिन, मर्नु पनि सक्छ. Right? So you have to take risk at some point of time. In any job you do, in hours also, you have to make a decision. Okay, afterwards your superior might say, oh, you did not record time, then that fellow died. You might have genuinely felt you would not have died. Probably उसको internal injury थियो, हैन? So it's you the best who have to think what you will do. Just don't do it. अब कोही बेला हुन सक्छ नि, you genuinely that what is your fault in that? You genuinely thought you will not die. That's why you did not record it. Just because one unfortunate incident occurred with you in your career doesn't mean that you can learn from that. You obviously learn from that. But it doesn't mean from next time, you just record it time. That happens, I've seen that. Just a small cut, a person is absolutely well and the time declaration has been done. And positive minded that you are about. So that is all in 32. Any questions on this?
यो चाहिँ कम्ती हुन्छ भन्ने जस्तै इन केसेस अफ आरटिए केसेस जो कोही टुरिस्ट आयो सपोज तमिलनाडुबाट कोही आयो जो चाहिँ हिन्दी पनि जान्दैन इङ्ग्लिस पनि जान्दैन खालि तमिल मात्रै बोल्छ अरे देन उसकै को अकुपेन्ट छ जो साथी थियो ऊ हिनोज इङ्ग्लिस हो ल्याङ्ग्वेज युजली चाहिँ हामीले अब डाइङ डिक्लेरेसन रेकर्ड गर्दाखेरि चाहिँ उसले त्यहाँ बसेर ट्रान्सलेट गरिदिन्छ मलाई
Yes, it can be done, but it still be a weak because the court will feel that the one who translated was interested. Suppose incriminating दिँदैछ, right? Road traffic RT भन्नुभयो, ड्राइभरले ऱ्यासली कुदाए यस्तो कुदाए भन्ने दिँदैछ, होइन? Obviously, the other was co-occupant. It will become very, very weak. Court will say that the other one, whoever translated, was interested in the outcome of the case. And the one who
त्यस्तो सिचुएसनमा चाहिँ के चाहिँ गर्नु
भिडियो गरेर कसो हुन्छ गर्दा त बट यु नो आई निड वाट बिकज यु सेड भिडियो के सल्भ गर्छ त्यसले क्यान यु कम आउट अफ द प्रब्लम वाट यु रेज बाई डुइङ भिडियो जज अल्सो डजन्ट अन्डरस्ट्यान्ड Tamil. Now there is no process in law to bring a third person and interpret what that person is saying because time person जुन चाहिँ सेट थियो त्यो सेटदेखि त कोर्ट पनि बाहिर गएर अर्को बोलाएर होइन द मोस्ट डिफिकल्ट थिङ टु प्रुभ इन टाइम डिप्रेसन द्याट पर्सन हु मेड द स्टेटमेन्ट वाज मेन्टली फिट टु मेक द्याट स्टेटमेन्ट द्याट इज वाइ इट इज युजली आई वाज युज डक्टर टु रेकर्ड इट अर द म्याजिस्ट्रेट बिकज इफ यु हेभ युज समवन एल्स हु is a person who knows, but you know, when you use a magistrate doctor, they have some responsibility. They are occupying certain official position, right? So they will try to justify the post they are holding by saying the truth, by being truthful to their duty. It's assumed, right? Accepted. But you have used some common person, not be bothered. So na ke loss huncha, that official position ma lai dignity ma लाग्नु सक्छ, court might comment something. So that mental state. Because the law at the same time says a person who is about to die or who has got very much injuries must be in pain, which has deranges his mental faculty even if momentarily. Therefore it cannot be relied. So this is one of the bracketing area which is difficult in a time declaration. Usually it's the doctors who certify that the person was mentally fit. To make that statement, I recorded it, he was absolutely fit. अब त्यतिले मात्रै हुँदैन कोर्टले पनि हेर्छ क्वेसन आन्सर सोध्दैछ भने या त स्टेटमेन्ट त्यो स्टेटमेन्ट पढ्दा त्यो मान्छे मेन्टली फिट लागेन भने त कोर्टले वाज नट मेन्टली फिट डिस्पाइट द डक्टर सेइङ समथिङ इट कुड बी द्याट दिस इज वान अफ द बिगेस्ट हर्डल इन देयर आर मेनी प्यारामिटर्स हु रेकर्ड्स इट वाट द पर्सन सेड एन्ड whether he was in a fit state of saying or not. But just merely person had many injuries on his body does not mean he was not mentally fit. The person may be having a small injury, still may not be mentally fit. There are cases where burn injuries. डढिरहेको छ त्यो मान्छेलाई स्टेटमेन्ट दिँदैछ hallucination मा छ कि केमा छ how do you know? area where the defense will attack. Whatever he said is false, त्यसको जिम्मा दिएर त ठिक छैन, and usually they succeed. Dr. Arun record त गर्छ, magistrate गर्छ, but it's neither his, it's the case of the police officer. You cannot control that magistrate what he likes. He's independent on that. उनीहरूलाई केसको बर्डर हुँदैन. Sometimes the question itself may come, let's suppose the defense are very, very clear. Let's suppose a doctor is emotional by character, right? Very emotional person. Like the daughter with the risk of Maya Lago. Now, whoever recorded was interested. A good defense lawyer has the power to demolish these things. So, all these are, as I told you in the first stage, your evidence is the primary one. Try to find that. The direct evidences. If you don't have, then we have no option. तपाईँकोमा direct छ भने पनि यो addition becomes more strong. But if you have only these things, sometimes it may be we have nothing else except these things. You have to rely on these only, and you can't do much about it. So 65B को जुन चाहिँ छ evidence for the time declaration. Sometimes this is sufficient law. Lawमा कुनै पनि यस्तो provision छैन जसले चाहिँ भन्छ यसकोमा मात्रै कन्भिक्सन गर्न सकिँदैन. टाइम डेक्लरेसनमा मात्रै गर्न सक्छ भन्ने पनि जजमेन्टहरु छ, but one has to be very careful. So एकदमै यसबाट कन्भिन्सिङ छ भने मात्रै गर्छ, otherwise 99% of the time only on this हुँदैन. कति डाउट निकाल्छ. Let's go to this certified. Xerox copies हाल्नु भएको छ चार्जसिटमा? होइन नगरी maybe the new generation of police officers may not be, but there are some, there used to be some cases where all are Xerox copies. What you have to discharge them. Section 62. Primary document context. Now, primary evidence means the document itself produced for the inspection of the court. Now, is it that you can never give secondary evidence? You can give. But there must be reason. Documents now. Listen carefully, okay? Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition or contents of a document in the following cases. When the original is shown or appears to be in the possession or power of a person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process of the court, or any person legally bound to provision. If the original is with the, let's say, a person against whom the document is sought to be proved, if the original is with the accused, it doesn't leave you. Right? But before that, then you have the copy. The accused says, I don't know. But you must have a ground so to the court that the original is with you, is not producing, or any person against whom it is tried to be proved. Secondary ल्याउन सक्छ, document हराएको छ भने ल्याउन सक्छ. But कोर्टमा हाल्दाखेरि चाहिँ suppose if it's the prosecution which is filing the Xerox copy, right? Then the prosecution must, before that is admitted by the court, must give evidence that it is lost, or it is in the possession of someone against whom it is being tried to be proved. जसको अगेन्स्टमा प्रुभ गर्नु खोज्छ त्यसले त original ल्याएर लु मलाई प्रुभ गर्दैन मलाई चाहिँ पठाउँछ भन्छ भन्दैन. But before that, it's a difficult thing. How will you prove that he has the original? It's difficult. When the existence, condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved. If the accused gives in writing, yes, this document ma je lekha cha Xerox ma correct. There no need to produce primary, secondary will do it. When the original is of such a nature as not to be easily movable. Usually what we all do this in bank cases. Right? Bank ko ledger चाहिन्छ, school ko register. Okay. Now this easily movable उहिलेको कन्टेक्स्टमा हो भने चाहिँ तपाईको ठुलो भन्नु जस्तो लाग्छ. तर अहिलेको कन्टेक्स्टमा I would interpret this easily movable. You can't move. Just pick something from the office and bring it. मलाई इन्टरप्रेट गर्नुहुन्छ अहिले इजिली मुभेबल डकुमेन्ट्स होइन बिकज वी जस्ट क्यान इन्टरप्रेट दिस वर्ड मुभेबल विथ जस्ट दिस साइन्स मलाई त्यस्तो लाग्छ when the original is a public document within the meaning of section 7 the public document हो भने चाहिँ you can bring secondary evidence but what is secondary evidence you must see that certified copies given under the provisions herein after contained that's section 74 copies made from the original by mechanical process which in themselves ensure the accuracy of the copy and copies compared with such copies. Now this secondary evidence is not your first instance evidence. First मा तपाईले प्राइमरी ट्राई गर्नुपर्छ र जुन 65 ले भन्दैछ यो केसेसमा म सेकेन्डरी दिन सक्छु भन्दै तपाईको त्यो सर्कमस्टेन्सेस छ भने तपाईले ल्याउन सक्छ सेकेन्डरी तर सिधै सेकेन्डरी ल्याएर व्हाट अबाउट द प्राइमरी भन्दाखेरि कोर्टले सो प्राइमरी वी हैव नो आन्सर then it becomes inadmissible. You must have that answer. Oral accounts of the contents of a document given by some person who has himself seen it. Now these are all, you need not go in detail, just to remember. Secondary evidence is this, your second priority. The first priority should be primary evidence. If that is not available, you see section 65, whether you can give secondary evidence of the document. If you can give it, you must show the circumstances which is compelling you to bring the secondary evidence. Right? The law is so much that, let's say, there exists the original deed, okay? And if someone comes and says, मेरो deedमा यो लेखेको छ, that is inadmissible. That document has to be. त्यो हरायो या त कुनै यो 65 कुनै ग्राउन्डमा परे किन ल्याउन सकेन भने मात्रै मुखले त्यहाँ के लेखेको छ भन्नु सक्छ. Otherwise, document को content चाहिँ मुखले भन्दैछ भने it is inadmissible. डकुमेन्टै ल्याउनु पर्यो. अब 74 मा हेर्नुहोस् त सर्टिफाइड public documents okay now not all are public following documents are public documents of the sovereign authority governance government documents say sovereign which is itself powerful okay? It's itself independent nothing controls it or any other constitutional authorities documents comes under sovereign authority official bodies and tribunals departments you might say of public officers any person holding public office are public officers. Legislative, judicial and executive, these documents of any part of India or so and so. Now these are the only public documents. Anything falling outside this are not public documents. So you just can't certify a private document and say it's a certified document. Private document over the original document. Right? Unless these type of other conditions exist. So section 74 ma jun chai public documents so you must public documents. Just don't treat it anything as other public documents. Now, how is this certification to be done? This is also actually a problem. Attested with certified just in this case. That's absolutely not according to the law. Certified copies of public documents. Every public officer having the custody of a public document. Now, who can certify? I have seen SSO certifying documents which is actually in the custody of someone. There was one case where the SSR certified the check bounce, check dishonorment. Can you certify it? Bank could have certified it. Certification does not mean that you are just comparing with the original. You are also saying at the same time that the original exists and this I am certified. Our public document must yaad raknu paryo original cha bhane pani you can bring certified copies. Every public officer having the custody of a public document which any person has a right to inspect, there are so many conditions, which any person has a right to inspect, shall give that person on demand a copy of it on payment of the legal fees therefore, together with the certificate written at the foot of such copy that it is a true copy of such document. Not just certified, certified is just a word. That he has to write that it is a true copy of such document or part thereof as the case may be, and such certificate shall be dated. You hardly find dates in the, especially while you are investigating, you won't find that in judicial work. In public offices, no No one puts debt under the skin. Do you know why? What is the reason? Even I don't know. I have a prison. Because debt is such a thing. If you have done something wrong, is that what we can do? You can always say I didn't sign it. I didn't sign on this date. Reason for a date डाले भने reasons दिनु बहुत सारा पर्छ. No होइन मैले यो तारिख गरेको होइन. Many public documents should not be biased or prejudiced. Avoid writing dates. Fearing that because official work, you see, administrative works can't stick absolutely to the law. Even financial rules I have seen, which is of 1979, can't stick to it in today's day, absolutely, somewhere or the other. So it's said, if you want to dig deep in any person's life, you find some background, no matter who that person is. So if a police investigation happens in any case, obviously you'll find something wrong. No one has done anything perfectly in this world. Right, so avoiding debt, right, and subscribed by such officer with his name and his official title and shall be sealed with seal. Whenever such officer is authorized by law to make use of a seal and such copies so certified shall be certified copies. I am the strictness I would have rejected so many documents. But as is law is blind, but it's not that blind also. You should certified copies. There are judgments which says, okay, the person has in fact certified, he comes and gives evidence, while certified correct or whatever. And even if it is not in this form, then it has been accepted. But the actual form should be this. This form there is no issue. Issue is certified the other side might raise an issue. It is not in accordance with law. What issue raised by accept even though it is not in accordance with law, it's a different matter. But if the forms are, whichever prescribed forms are there, if it is complied with, it avoids issues. If you don't comply with it, then it will give a burden on the issue. And you as an investigation officer, you are already solving one issue. You don't want one more issue to crop up in your investigation, right? Which is not related to the facts of the case at all. It is a certified code. You just can't put just right, certified. It does not mean certified. It can only be certified by a person of those documents which are public in nature and who has the custody of them. I can't certify your Sadar Khana's document for the purpose of Evidence Act. So avoid getting it certified by someone who has no custody of that document. Usually this will be also a difficult task for you. Custodian will refuse to sign it. So it's a difficult job which you all have. If you really work according to law, it will become not only become difficult, but it might fire back also. That's everywhere for everyone, including us. But in the judiciary, because we are independent, so we are safe from that. No one says us to do this or do that. We have the liberty to apply our mind and do it. But in your cases, since you are one of the wing of the government, you might have difficulties. It's for you all to tackle. So any other sections have I left which is relevant to you all, which I have not discussed or we have not discussed? All the port code. Okay, any other question you all have in mind? 15 minutes. I'll be happy to answer. Proper investigation to understand law and ordinary arrest arrest गर्दैछु but proper investigation of the case किनभने यो केसमा चाहिँ यस्तो फ्याक्ट छ arrest गर्नु जरुरी sufficient. The magistrate will not go deeply behind that. The magistrate will try to dig it out if you have just written for proper investigation. They will not go behind your reason unless it's so unreasonable on the face. But if you are not giving the reason, then the magistrate, because you see Arnest Kumar's judgment, what it says in the police officer who arrested the person, as well as the magistrate who gave the remand, shall be subject to disciplinary proceedings. Magistrate को mind में तो क्यों नहीं? तो चीज़ों में ना, it hasn't been done so far, but I think one case is there for our High Court. I think it's not for much when this issue is there. Both the police and magistrate for the state of the or Facebook issues. To be frank, you will not get anything from Facebook or WhatsApp. You will not get it. The only way out is through magistrate, it goes to the external affairs ministry. And they will study it, whether it's required or not. There must be a reciprocal arrangement between two countries, whichever is supplied. To go from there, never I have anything. Officially, we will not get it. So when these cases are difficult, the moment it comes, you should start looking for other evidences available. Yeah, I think there's one case where police officer has said, it's not police, it's a complaint case, where the person is saying these are the office persons on Facebook. Now, who are those? Do they really exist? No, correct? Which is not. It will come to FIR case ma hunनु सक्छ. Facebook ma त छ नि. त्यही मान्छे हो. यो पक्रेको छ त्यही मान्छे हो त भनेर रिपोर्ट गर्नु पर्यो. Facebook ma के हुन्छ? No one will rely that Facebook. Photo छ अब. It could be a tool for you to investigate, but as an evidence, and like this you will not be able to do much in these cases also. Not only here, in the entire country. Cyber cases are difficult to get proved in the court. You do not get evidence on the conversion. That is why this new rule has come in the IT rules, that any, just like if it's Facebook, if it's WhatsApp, they should have a office in the country in which the Facebook is operating. Just like the Indian law says that Facebook was, WhatsApp was, Twitter was. एउटा मान्छे हुनुपर्छ इन्डियामा जसले चाहिँ रिक्विजिसन गर्दाखेरि चाहिँ should be in a position to give this document. Because तपाईँको jurisdiction भएको अफिसरलाई त you can grip him, no? Someone staying in foreign, you can't do anything. But these rules has been challenged in the Supreme Court, saying it violates their way of doing business. WhatsApp has challenged very much. So unless this happens, cyber cases, you'll have to do something. I won't say forget it, but it's difficult. Even if the charge sheet is filed before the bank statement money at the 65B change. Not only 65B, Bankers Book Evidence Act one is section 3A one is even change the 65B change. So never bring bank statements without 65B or Bankers Book Evidence Act section 3A or 2A certification. Anything? Or we can close.
Sir, your question, sir. आयोहरूले कहाँनिर मिस्टेक हुँदाखेरि चाहिँ कतिवटा केसहरू पुरा एक्युटेड हुँदैन र त्यसलाई कसरी करेक्सन गर्न सक्छ होला अब आउने चुनावमा जस्तै पुरा साइबरहरू पनि हुँदैछ जस्तै थेप केसहरू छ सर अहिले हेऱ्यो भने साडा एनडिपिएसमा त अब जस्तै हामीले माथि लगेर जान्छ कोर्टमा र एक दुई दिनमा चट्टै बेल गइहाल्छ र के सर कतिवटा चिजमा चाहिँ हुँदैछ छिट्टै गइहाल्दो रहेछ त्यसले गर्दाखेरि
SADA is most stringent than NDPS information. SADA and NDPS ma bail taba matai huna sakcha for your understanding. If the court feels that there is no case against the person, there is no ground of reasonable belief that the person is guilty of law. So ordinarily bail should be rejected something, you will not get the What was the next? Oh, I wouldn't square what. I would say it's the non-understanding of these evidence processes. त्यही लाग्छ मलाई कि जस्तै जेरक्स कपी ल्यायो त ल्यायो नि तपाईँले सायद सही कुरै ल्यायो कोर्टले त हेर्दैन कोर्टले भन्दैन तपाईँ जेरक्स ल्याएछ जेरक्स पिपीलाई भन्छ पिपीले कम्युनिकेट नगर्ला जस्तै सर्टिफाइडमा someone else has certified who is not even the custodian of the document. Court will not rely on that. Okay, just like he said, there is blood stain on the wood, but it's not examined. Best possible evidence ल्याउने चाहिँ ट्राई गर्नु पर्यो because you are trying to prove a case before a person who has not seen it. The judge has seen nothing. देख्यो भने जज बस्नै हुँदैन त्यहाँ. If the judge himself has seen some incident, he or she cannot sit there as a judge. That's the rule. Absolutely blind mind भएको मान्छेको अगाडि चाहिँ you must take something and say this is it. अर्को मैले देखेको जस्तै साइकोलोजिकल जस्तो लाग्छ तपाईँहरू इन्भेस्टिगेसन गर्दै जस्तै तपाईँ स्पटमा गयो खुकुरी भेट्यो तपाईँ त कन्भिन्स हुँदै जाँदैछ नि त यही मान्छे रहेछ तपाईँलाई पहिला याद हुँदैन एउटा वाक्कुला सोध्यो द्याट्स your personal satisfaction. You are satisfied. यही मान्छे हो but how will you satisfy the court? Hasn't been to the spot, hasn't talked with the witnesses so far. So त्यसको लागि ग्यादर गर्ने चाहिँ एभिडेन्स चाहियो. So never mistake the belief that your satisfaction is both satisfaction. Your satisfaction should be about when you feel that yes, I have the evidence to prove the case of this person. And usually one thing I kind of avoided. I always didn't like that. But I was right in the same day. In view of the investigation of indictment, investigation about there's a prima facie case against them. Is that a correct word, prima facie? Why have you? You are a charged. Prima facie late, sir. What does it mean, prima facie? भन्नुहोस् त माने के हो prima facie? डिटेल पढ्नु पर्दैन नि. तपाईँले भनेको छ अरे यो मान्छे यो चोरी गर्यो यो मान्छेको फिङ्गरप्रिन्ट पाइयो कोर्टले सट्ट चार्जसिटमा हेर्छ फिङ्गरप्रिन्टको प्रुफ छ कि छैन यो मान्छेलाई सिसिटिभीमा देखेको कोर्टले सट्ट हेर्छ सिसिटिभीको के हालेको छ द्याट इज सफिसियन्ट डिफरेन्ट चार्ज बट यु योरसेल्फ सेइङ ओन्ली प्राइमा फेसी केस इज देयर मिनिङ डिपमा चाहिँ केही छैन यहाँ यसो माथि सुपरफिसियलिटी छ भनेको जस्तो यु मस्ट से द्याट दिज आर द एभिडेन्सेस विच इज सफिसियन्ट to prove the case against the accused or whatever you can. Or these are the evidences which shows the guilt of the accused. Right, determination त किनभने त मेरो अनुसार त नि जजमेन्ट कोर्टबाट निस्किनु भन्दा पहिला त तपाईँहरू हो जज जब तपाईँ नै एभिडेन्ससँग सेटिस्फाई छैन कि यसले प्रुभ हुँदैन भने देन वाट विल बी कोर्ट डु तपाईँ कन्भिन्स्ड हुनु पऱ्यो नि दिस इज सफिसियन्ट टु प्रुभ द केस अगेन्स्ट द पर्सन द्याट इज नट जस्ट प्राइमा फेसी वा यु it's a proof case. But since you cannot order guilt, since you cannot write judgment, since you cannot do trial, you'll have to put it before the court. Right? So legally you are not the judge. It's easier to convict the person. If you don't have it, you are yourself saying prima facie. So what word you use is up to you, but don't just use word that prima facie. In view of the other prima facie case is found against them, you only found prima facie on the face. That means there is nothing below that. Right? So, correct those words. All of you have finished your probation.
Sir.
But now it will start. I would say remand rejected, I would be so happy. Because he got the ground, I didn't do anything, the judge rejected it, I arrested him. Thank you, sir. They used to go so fast. So these are all systems, we all live in a system, we all just 2 years. After 2 years. What's your name? What is it?
Ashim Rai.
Which place? Okay, if there's no anything else, then Director sir, we have finished.
The duty mandatory हो कि एउटा मात्रै
If you bring a school certificate, that's all. You go by JJ Act. JJ Act I think it's 94. Section 94. जुन चाहिँ order मा छ नि, that is the order follow गर्नु.
त्यो पाएन भने त्यो पाएन भने त्यो. But yes, it depends upon the case also. Sometimes what happens is schoolको you may have a doubt. Okay? तपाईँको जाने चाहिँ, that's why I said, no, it's your duty of collecting evidence. If you are not, just the law says this is in priority, you have to bring this document, doesn't mean things end there. Law says one thing, investigation is purely based on the facts that exist in a particular case. You have to prove those facts. Law ले यो document भनेको छ, म यही मात्रै हाल्छु. Even though if you are finding that document is not reliable, there is something wrong. तपाईँले इन्भेस्टिगेसनमा थाहा पाउँछ नि, त्यो डेट अफ बर्थ कसले दिएको, आमाले दिएको, स्कुलले कहाँबाट लेखेको खोजी गर्नु पऱ्यो. It's not sacrosanct, it's not absolute truth what is written there. साँचो हो कि होइन त्यो डेट अफ बर्थ. That will be there in your mind. Don't file birth certificate instead of that. But your duty is to find the best evidence that is there. It's not necessary that mandatorily you have to file both, but it depends upon your facts also. Which document is reliable that can prove that. But if you have school certificate, instead of taking that, if you go down in the bottom and bring that, then there is the defense question. Which is school certificate, that is the document.
So this, in addition to what the learned resource person shared just now about the birth certificate, if there is a birth certificate, then school certificate, on top of that you make extraordinary these exercises and includes radiological examination, then means you are not 100% sure about birth certificate, and so you should not do. There is a judgment of Honorable High Court of Sikkim also. When there is a birth certificate, school certificate, no need to go for radiological examination. If these two documents are not there, then you can go for bone test. But you should not file charge sheet saying that there is no birth certificate, no school certificate. So these are the version of parents, whatever. So it got something. This is a radiological examination. The last option, no. One goes section 94, sir. Section 34 पनि छ पक्सो एक्टमा. अनि जे रुल्समा पनि छ. तर त्यही छ हाम्रो अनेबल हाई कोर्ट अफ सिक्किमको जजमेन्ट चाहिँ कहाँ गएर एक्युटर हुँदैछ भन्नेलाई चाहिँ त्यही हो कि बर्थ सर्टिफिकेट, स्कुल सर्टिफिकेट चाहिँ इन्डियन इभिडेन्स एक्टको धारा नम्बर 67, 62 मुताबिक चाहिँ प्रुफ भएन. र आँखाको अगाडि हामीले लेख्छौँ नानी चाहिँ सानै थियो, नाबालिका, खुदै हामीले एक्जामिन गरेको, सानो छ र पनि हाइकोर्टमा के भन्दै आर्गुमेन्ट गर्यो भनेदेखिलाई चाहिँ डकुमेन्ट्री इभिडेन्स चाहिँ प्रुफ गरेको छ. सानो छ, आँखाले देखिरहेको छ. हेर्नुहोस् है, आयोगलाई पनि चित्त बुझ्दैन, सबले कोर्टलाई पनि प्रिसाइडिङ अफिसर पनि चित्त बुझ्दैन, स्पेसल जजलाई पनि. तर के छ, कानुन हेर्नु पर्यो नि. हामीले इमोसनल भएर त्यो प्र्याक्टिकल आफ्नो भ्यू पेश गरेर हुँदैन. इभिडेन्सले के भन्छ त्यही हेर्छ. त्यसरी एक्युटर हुँदैछ. के छ अरू तपाईँको क्लियरिफाई गर्नुपर्ने कसैको?
One more thing in Foxo, यो 164 रेकर्ड गर्छ नि त. एफआइआर भएको हुन्छ एउटा मान्छेको अगेन्स्ट है, 164 रेकर्ड गर्दै गयो. You have to investigate the case against that person also. Yes. Just 164 मा भनेको हुन्छ नि, लास्टमा तपाईँहरूले त्यो अफिसको नाम मात्रै थपिदिन्छ. यो पनि रहेछ यहाँ भनेको छ. हुँदैन, उसको त इन्भेस्टिगेसनै भएन. This is lying. I think
Yes, sir.
anything
Kimsen.
related to you? Your brother?
Legal it's
Oh,
yes, sir.
he's in forest or something.
Yes, my brother, sir.
Your brother or elder?
Elder brother.
This is he knows.
Yes, we have come to the conclusion of today's program. Yes, definitely it's my honor and privilege to conclude the same by offering vote of thanks to all present here, especially the learned resource person who, as I've said in the beginning only, keeping aside of all important assignment of Honorable High Court of Sikkim, he has given consent to conduct today's sessions, and while conducting the sessions, a number of issues cropped up, and I think the all police officers must have clarified, and hope that definitely those whatever you incentives you have given, you have received during the course of this session, use while handling a number of cases in days to come. So, in this regard, I, on behalf of Sikkim Judicial Academy, would like to offer sincere gratitude to our knowledge resource person for sharing precious time, knowledge and eminent views and making a remarkable and wonderful contribution to all of us here. I once again would like to offer sincere thanks, sir. And at the same time, I would also like to offer my sincere thanks to all police officers who, again, keeping aside of all important assignment given to each of them by their respective police officers, after getting the direction from the concerned officer of police department, come here and actively, consciously participated in this session. I must offer my sincere thanks to all. Thank you so much. And lastly, definitely I have to offer my sincere thanks to my staff who have come early in the morning and make all arrangement, including the photographers, GT Catering Enterprises, for preparing delicious lunch for all of us here, and making the entire session of program a very special, vibrant and successful. Thank you so much. Now let's have a photo session down in the ground floor, then request everybody to proceed banquet hall for lunch. Thank you so much.